Hello students, welcome to my channel. In this channel I am giving you tips about Indian constitution, polity, and we are also solving some of the questions from UPSC previous year papers, which will help you to acclimatize you to solve these questions in an easy manner. And today we are going to see a polity question from UPSC prelims 2021. So if you look at the question, this is a little confusing question and it confuses a lot of students, but the confusion, why it confuses the students, I'll let you later, but we'll first see the questions and analyze it. With reference to Indian judiciary, consider the following statement. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with prior permission of the President of India. Next, a High Court in India has the power to review its own judgment as the Supreme Court does. Which of the following statements are correct? 1 only, 2 only, both 1 and 2, neither 1 or 2. Now, I have always told my students or anybody asking for the tips to solve polity questions is the number one tip is that you will have to use only the Indian Constitution as the source to solve the questions. If it is a question that is asked from the Constitution of India, the only source should be the Indian Constitution. Many students make the mistakes of looking into books that are available. There are lots of popular books for constitution in India. Some include Lakshmikant, Durgadas Basu, a lot of books. But what matters is only the Constitution of India. So if you look at the first option, any retired judge of the Supreme Court of India can be called back to sit and act as Supreme Court Justice by the Chief Justice of India with prior permission of the President of India. So whether this is given in any of the articles of the Constitution, I have the Constitution here, and if you look at Article 128, it clearly says what is given in the first option, that is, notwithstanding anything is this chapter, the National Judicial Appointments Commission. Of course, the National Judicial Appointments Commission has been held to be unconstitutional by the Supreme Court itself. So if you look at it is instead of the National Judicial Appointments Commission, it should be the Chief Justice of India. So the Chief Justice may at any time, with the previous consent of the President, request any person who has held office of a judge of a Supreme Court or the Federal Court to sit and act as the judge of the Supreme Court. So clearly option 1 is correct. Now let us move on to option 2. If you look at option 2, a High Court in India has the power to review its own judgment as the Supreme Court does. Now there are two aspects to this option. One is whether the High Court has the power to review its own judgment, and the second is what is the power of the Supreme Court with regard to reviewing its own judgment. Now again, I told you the number one source for answering this question should be Constitution, and if you go to the Constitution, the Article 137 clearly gives the power of the Supreme Court, power to the Supreme Court to review its own judgment. If you look at review of the judgments are ordered by the Supreme Court, the Supreme Court shall have the power to review any judgment pronounced or order made by it. Next, coming back to the question, the option says whether High Court has the power to review its own judgment similar to Supreme Court. Again, we'll have to go to the Constitution of India to find out the answer. If you go to the Constitution of India, let's go to the chapter on High Courts, whether there is a similar provision of what we saw in Supreme Court, that is 137, whether there is any provision similar to Article 137 given to the High Courts. So here if you look at Chapter 5 talks about high courts in the state, the high courts for states, high courts to be courts of record. Then 216 Constitution, appointment and conditions, application of certain provisions into Supreme Court, High Courts, oath, restrictions, salaries, transfer, appointment of acting judges, appointment of additional acting judges, then retired judges. Now this is very similar to 128 that we saw earlier for the first optional, jurisdiction of existing high courts, and then power of the high courts to issue writs. 226, 227 is there, 228 transfer, 229 office and servants as expense of high courts, 230, 231, and then we go to subordinate courts. So clearly there is no such corresponding power to the high courts as we have for the Supreme Courts under Article 137. So this option is wrong. So this option is wrong. So the correct answer to this question is A1 only. Now many of the students gets confused in this question, because if you look at the Lakshmikant book, in Lakshmikant book he has given that a high court has a power to review its judgment by virtue of being a court of record, or under Article 226, or even through CPC, that is Civil Procedure Code. Now these are very narrow and limited provisions, and the power of the High Court to review those judgments are very, very limited and narrow, and this is not as wide as compared to what the Supreme Court has under Constitution. Besides, the Constitution did not give any such power to the High Courts, and these are some of the, when I say being a High Court being a court of record, or under 226 they have the power to review judgments, these are some of the observations made by High Courts in deciding cases, and those do not form authority in Indian judiciary as something that is given as a judgment by the Supreme Court. So that is where the confusion comes in, and many answer keys got this option wrong, because a lot of people, for them the source is not the Constitution. They look at popular books like Lakshmikant or Durgadas Basu or what has been written, and unfortunately they will get this question wrong. And another way to check this answer is that clearly the Constitution makers have given such power in 136, but no such corresponding article in the High Courts section. If you compare the Supreme Court with the High Court, there are various articles that are similar, like the retirement of retired judges sitting in the Supreme Court. Now, but there is no such corresponding article for 137. If you look at article 224, appointment of richer judges. Similarly, High Court, with the previous concern, request any person who shall office as judges of High Court or any court to sit as judges of the state, High Court for the state. Very similar to what we saw in 128. So the Constitution makers have given similar powers to both the Supreme Court and the High Court with regard to option 1, but with regard to option 2, clearly there is no such similar corresponding article. So clearly the answer should be A1 only. The reason why I made this video is because I always say, when you are trying to solve questions on Constitution of India, the only source, the simple source that you have to see is the Constitution of India. Do not Google it, do not try and overthink this question, because there are a lot of chances that you might get it wrong. Thank you for watching this video. If you like this video, do share it with your friends or anyone who is preparing for civil services for whom this video will be helpful, and do subscribe to my channel and share this video. Thank you.